Hear ye, the Honorable Chief Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning. Our first case is 2020-290, the State of Ohio versus Sherry Tidwell. For the appellant, first we'll have Mr. Cummings argue. Mr. Cummings.
Good morning, Chief Justice O'Connor, Justices of the Supreme Court. I would like to speak for 8 minutes and then reserve 5 minutes for amicus. And then additionally, I'd like to reserve 2 minutes at the end for a rebuttal, if I may. Your Honors, the case before you today was a perfectly proper, constitutionally reasonable stop. The trial court got this issue wrong, and so did the Court of Appeals. And the reason's clear. Both courts misapprehended the legal significance of an on-site citizen contact with a police officer. And because both courts misapprehended the significance of that citizen informant contact, they miscategorized this case as an anonymous tip case, and it's not. It's a citizen informant case. And once they miscategorized this as an anonymous tip case, the die was cast because they went down the road that pretty much dismissing everything else, all the other circumstantial evidence, and pretty much said, hey, this person was unidentified and unnamed, this is unreliable, therefore the search and the stop is unconstitutional. And Your Honors, that is just legally wrong, and it's against common sense as well, and quite frankly, it's quite dangerous. So this court today has an excellent opportunity not only to correct the error in this case, but to reaffirm the concept that citizen informant cases like this deserve special consideration. The tips of a citizen in this type of situation, they are entitled to deference. They are considered of higher reliability, and that's for a reason. These reasons have been stated by this court actually in Wisner, and that's the basis for the three-step category that we use to categorize tips. I know this court is aware of that. The most unreliable is the anonymous tip. And then you have the known informant type tip, which is usually somebody that's worked with police before of the criminal world. So they have a history of perhaps providing reliable information, but they're not really all that reliable, and you want some cooperation if you can get it. Certainly you want cooperation with an anonymous tip. But the third and the most reliable type of tip is that of the concerned citizen, the citizen informant. And I think that unfortunately in this case, because the name of this person was not in the record and the officer did not identify this person before leaving the scene, both of the courts below grabbed on that, and that was basically determinative of their analysis. And that's quite unfortunate because that's not what the totality of circumstances analysis contemplates, and it certainly is not dictated by the record that was developed in this particular case. The factors that we had in this case that justified the officer's actions are overwhelming in favor of the officer taking the steps he did. The citizen approached him. The citizen initiated contact. He looked at the officer looked at the citizen, and the citizen yelled, "Hey, you need to stop that lady. She's drunk and she's about to drive," essentially. And so at that moment, what did the officer have? He knew that he had the report of a crime, possibly not one of a past commission, but one that was ongoing. This is in real time. He had an identified person in an identified vehicle. She was parked in her Hummer, and it was in a specific location. He knew all that. He also knew, or the law knows at this point, that the citizen who just stepped forward is entitled to great reliability. And in a case like this, where the allegation is so serious and has such potential public safety consequences, the need to act on such information is apparent, and it's encouraged by the case law. And at this point in time, the officer was absolutely justified in taking this seriously and doing the very minimal step of at least walking towards this woman and looking at her and seeing what he could determine.
Mr. Cummings?
Yes.
So I was trying to clarify the facts. So she was in a Hummer in H3. So did he actually reach in and take her keys out of the ignition once she rolled down her window and stopped backing out?
No, I think he requested the keys, and I think she handed the keys to him. But that was after a period of time. He first looked at her, I think, before she noticed him, and he noticed her blank stare and her glassy eyes. And then he got her attention, and he motioned for her to stop, and she did. And at that point in time, I think we have to realize that this is an investigatory detention at this point. And I think that can be clearly conceded, but I think it's also clearly justifiable, because everything that he knew justified him taking the minimal step that he did. And then the longer time he spent interacting with her, the reasonable suspicion, the probable cause just increased.
So what I'm trying to get at, because
Yes.
this is a really close case, what I'm trying to get at is at what point did he ask for her keys? Had he smelled alcohol, or was it just the blank stare and the backing slowly when he asked for the keys?
Sequentially, I think it was after he struck up a conversation with her. He asked her where she's been, what she's been doing. He asked for her license. I think it took some awkward seconds, almost maybe a minute, I think he said, for her to pull out her license. It was a very unusually slow and prolonged process. And I think by the time he smelled the alcohol, at that point, he was smelling the alcohol and noticing her exaggerated, slow movements. And I think it was after those things occurred that he asked for her keys, and she handed those to him. He took them on top of her car, I believe.
And just to be clear, she had already moved the vehicle. The vehicle was in motion when he stopped her.
Correct. She was starting to slowly back out of wherever she was parked.
Okay.
And I know that's been mentioned, that is not per se erratic driving, and taken alone, that's a neutral thing, and I understand that. Yet the case law says even innocent actions, sometimes taken in context, can further reasonable suspicion. So that cuts both ways here. In hindsight, she was moving very, very slowly in everything she did, not just backing up the Hummer, but in fumbling with her license and trying to comply with his requests. Her exaggerated slowness was just a corroboration that the citizen informant was dead on. This woman was drunk.
Would it have been unreasonable for the police officer to follow her to see if her driving was erratic?
Absolutely. I mean, when you have corroborated information of a drunk woman who's about to pull into a public street.
Let's just say a drunk person.
Okay, but I understand. A drunk person in a big vehicle, the public safety here is, you must balance that, and it weighs heavily in favor of taking the action the officer did. You have to eliminate the risk of that type of drunk driving immediately. He would have been remiss had he not. I'm sorry.
Also, what you had here is exigent circumstances. Would you not agree?
Yes, in a way, yes. I mean, you're talking about it. It's a balancing act. Delaware versus Prowse says you have to balance the intrusion with the governmental interest involved. And in a case like this, where a driver is about to go out drunk and drive on the public roadways, that's an exigent circumstance, absolutely, in the sense that it presents a very, very dangerous situation that must be considered.
Do we know, Counselor, do we know if the officer was finished with the business that he was originally there for? I mean, was he still kind of between both scenarios? I believe he had pulled over someone and he was doing something else official when he got the information about the potential drunk driver.
I think he was finishing up. I don't think he was completely finished.
Okay.
Yes. I'm sorry, I can see that I've gone over time. I'd like to step aside now and let Mr. Carney speak if I could.
Mr. Kearney?
Thank you. Good morning. May it please the court. Two principles govern this case, and they're both uncontroversial on their own. And the way they interplayed here don't undercut either one, either the citizen informant rule or the snapshot rule. And together they show this tip was reliable and Sergeant Alonz did the right thing when he stopped Tidwell before she drove off drunk. The citizen informant rule, as the state already explained, is that you're presumptively reliable. You don't count as anonymous just because you haven't had time to give your name yet. The snapshot rule that this court's discussed in Dayton v. Erickson and a host of cases is that we judge everything by the split second where the officer has to decide, not by after acquired evidence. And I think that's what threw the lower court off here, because most of the time that rule cuts against the state. When the state doesn't have enough evidence for a stop and they try to point to, well, it turns out someone was drunk, or turns out there were drugs in the car, the courts rightly say, no, you can't judge how it played out. You have to judge in the moment. And I think the best way to resolve this case is imagine it happened the same way to start. Someone yells, stop that car, that lady's drunk. And then it turns out after he stops the car and freezes that situation, that he goes over and this witness pulls out an ID and tells this full detailed story of, I saw her stumble in the store, she slurred her speech, she threw up on my shoes, all sorts of detail. Well, that case might seem stronger, but it's not, because legally that's the identical case at the time he heard someone say, stop, she's drunk. And where the appeals court was wrong is in saying, well, the tip should have had more detail. The Kansas Supreme Court did a really nice job in the Slater case explaining this, that a conclusory statement like she's drunk is the kind of thing that lay people know. They don't tend to itemize, especially with the urgency of, death and danger, right? Any second now. You don't tend to list specific things about slurred speech. We all know drunkenness when we see it, and we don't need a Rule 703 expert qualification to opine that someone is drunk. There's also no time for that detail. And I think if we all ask, what do we want the next Sergeant Alance to do tomorrow? We know what that answer is. He may have saved a life here. He may have saved Sherry Tidwell's life. And so that's why waiting for something else would not have been reasonable. And again, if you just judge by that moment in time, this case is very straightforward, because we know the citizen informant rule from Wisner. We know the moment in time rule from Erickson. And this is a matter of just putting them together. The other thing is, if you zoom out and you think, is this reasonable? We know what that answer is. But if you zoom in more and ask, we have these classifications of anonymous or known informant or citizen informant, but really those are just shorthand for characteristics that this court discussed in Wisner of, is there veracity? Is there reliability? And here, all those things, no reason to lie, immediacy, those all cut in favor of allowing this stop here. Again, she turned out at a .213. We didn't know that at the moment, but we knew someone getting in a Hummer, that is life or death. We all want that situation to be stopped immediately. We should be thankful Sergeant Alance did the right thing here, and this court should uphold the stop and again reaffirm that a citizen informant is presumptively reliable, as this citizen was here.
But Mr. Carney, what if that unidentified person had been wrong? And what if she, this is a case that's so specific on the facts, and if we turn this into basically a rule with our decision, then what about the person who's wrongfully detained in the future based on what amounts to an unidentified person who got the information from somebody else and then called out to the police officer, and the police officer went ahead and detained the person just based on that? I mean,
well,
are we harming people that way too?
There are two answers to that, Your Honor, and I'll try to be really quick because I want to save Mr. Cummings' rebuttal time. But first, that's why the court says presumptively reliable. If there's actually some affirmative indicia of unreliability, then there might be some tipping point where you can't do the stop. But what this court says in balancing, this is such a minimal stop, don't roll off yet, that the worst thing that happens is if you go over to the car and she's perfectly fine, she goes on her way.
No, excuse me, but he took her keys. He took her keys, and it's okay to stop and have a consensual encounter, which is what it could have been at first. But once he took her keys, she was detained.
Well, Your Honor, the most important thing here is the initial stop where he says, don't drive off yet. Once he started talking to her, he did notice then the speech. He did talk about her glassy stare. He asked her for the keys and she handed them over. At that point, he was witnessing that firsthand, but he also had a witness, a citizen informant. That doesn't count as anonymous. When you're in public, you don't count as anonymous just because you haven't shown an ID yet. And that is enough to say this person is drunk. After all, they didn't go to a full-scale arrest till the other officer came, a sheriff's deputy, and did a drunk test. People get pulled over and asked to do drunk tests. I was once years ago, and I was perfectly sober, hadn't had a drink, and then I was let to go on my way. I did get a speeding ticket, but I did not. If you're not drunk, you don't have a problem. If it turns out, there are stops that turn out nothing's wrong here. If someone was just weaving because they changed the station or something on their car, there are times that there are missed calls or mistaken calls. The question is, do we want to err on the side of safety, or do we want to risk life or death? And here we err on the side of safety. We have other tools designed if rules get abused, but here the officer, turned out right. The citizen was right. And again, we may have saved a life that day. And I think we all want the next Sergeant Alons to do the right thing and stop someone.
But Mr. Carney, but Justice Stewart suggested maybe he could have followed her.
Well, this is a busy intersection on Montgomery Road in Cincinnati, pulling out of a speedway. I respectfully suggest that it's one thing when someone's already driving to say, can I risk? And even then, this court in Wisner said continuing to drive and follow wasn't necessary because someone reported that a car was weaving. But if you have a chance to stop someone before they pull out in traffic, to say, just pull out, I'll rush into my car and follow and hope for the best. If I were driving on the street that day or my loved ones were, I wouldn't want the officer to wait longer. If they didn't have reliable information, sure. But when someone says that lady is drunk, again, the average citizen knows what drunk looks like. And so that is shorthand, as the Kansas Supreme Court put it, shorthand for the things that even the appeals court said here. This might have been good enough in the appeals court's view if he had specified, I saw her drink several alcoholic beverages. Well, I don't think we need to engage in that fiction of saying we don't understand out of common sense. When you say someone's drunk, that means they've consumed several beverages. That means they've exhibited some physical signs, whether it's speech or whether it's stumbling movement or something.
Counsel, wasn't the testimony that the clerk in the store was alerted to her intoxication and I believe still sold her alcohol, and then immediately remorseful, I guess, or scared, tells this other customer, hey, this woman's drunk. I mean, he gave some direction to so it was upon two observations, not just the citizen informant.
Well, Your Honor, that is all absolutely true. It did turn out that instead of the usual buyer's remorse, we had, I suppose, seller's remorse, that the clerk said, get that cop because he saw the lights out there, and relayed it. I think the important thing, though, is while that does further corroborate what happened here, that I have to take the good with the bad, that if you judge by the snapshot rule, as I call it, that when the officer had to decide in this split second.
Right. He didn't know that, right?
He didn't know any of that. So this case is the same, whether it turned out that the customer was relaying what the clerk said, or the customer had seen it himself, or as I said, if the customer had seen some outrageous set of stumbling and slurring and, drinking in the aisle at the store, none of that matters, because just saying conclusorily, she's drunk, incorporates a set of common sense human judgments of that must mean someone is dangerous. For example, one of the things the appeals court said is, well, this tip contained no predictive information. When you say stop that car, that lady's drunk, the prediction is implicit. If she gets in that car, she's going to drive drunk and someone's going to get hurt. You don't have to say it in so many words and use too many words like I do. You can just say, stop, drunk. And that's the bottom line here.
Thank you, Mr. Kearney. Mr. Brittingham?
Thank you, Chief Justice. May it please the court, opposing counsel. Merely having a line of sight with a police officer does not transform an otherwise anonymous individual into a citizen informant. Appellant has defined a citizen informant as not an anonymous tip and not a known informant. If the unidentified individual here is not anonymous, then there is no anonymous. Reasonable suspicion is the undisputed standard here. In Borum and Wisner relied upon heavily by appellant, the court stated that an eyewitness account of criminal activity is due greater reliability than a secondhand description.
Mr. Brittington, how is he anonymous if the person is right there in front of the police officer's face?
Well, when the Supreme Court was looking at Navarrete, so a lot of the cases by both sides deal with callers, and other cases cited by both sides deal with in-person individuals. In Navarrete, Justice Scalia, in his dissent, noticed that law enforcement officers are likely to take away from that case that anonymous 911 accusations are not as suspect and hence as unreliable as other anonymous accusations.
Counsel, let me ask you this. When I read the facts of this case, I couldn't help but wonder or analogize hearsay exceptions. The reasons we allow hearsay exceptions is they contain certain indicia of truthfulness, like an excited utterance. How does this situation not differ from that? An anonymous tipster calling in might have all sorts of nefarious reasons for doing so, but in our common experience, usually people don't come out and say, make an accusation in person that is false. Would you not agree with that?
I wouldn't necessarily agree with that, Your Honor. I'm glad you brought up the hearsay analysis, because what we have here is hearsay upon hearsay, because we have the clerk from the Speedway relaying information to the individual, and the individual relaying that information to Trooper Islands. Also, below, there was no testimony elicited as to the tone of the tip. Was it matter of fact? Was it excited? Was it urgent? There was no testimony about that.
Again, what difference does that make if the person is in front of the police officer and says that person is about to drive drunk?
Correct, but in Wisner, in Oney, in Ramey, all cited by appellant, the individuals in those cases made concerted efforts to seek out this officer. And that's not really what we have here. We have a passing 2-second statement where the person, the unidentified individual, relayed information to Trooper Islands, and then he left the scene, never to be seen again.
Well, why is that the state's fault or the police officer's fault that the citizen informant left the scene?
Well, Trooper Islands could have done several other things here. He could have, I'm sorry, I'm switching my notes here. He could have asked for a name. He could have asked the unidentified individual to stick around.
Okay, but doesn't that all cut against your argument? Because at the time that the person made those statements, she didn't know that the officer wasn't going to say, wait right there until this is over, right? So, there's a lot more risk lying to a police officer when you're face to face with the police officer. The police officer can stop, can make you wait. You don't know what the officer's going to say. Than someone in the typical anonymous cases that you rely upon where it's just a phone call.
Well, that could be, Your Honor. However, if in person always equated to truthfulness, then we wouldn't have a need for statutes like obstruction of official business or falsification or perjury.
But it doesn't have to always equate to truthfulness. That's not the standard here. The standard is there just has to be a reasonable suspicion. Is someone who is saying something to a police officer's face, is that enough to create reasonable suspicion?
No, it's not, Your Honor. And
well, let me ask you this. We're told over and over again that the touchstone of the Fourth Amendment is reasonableness. Do you think it would have been reasonable for a police officer who's just been told that someone who is intoxicated is getting ready to drive a Hummer into busy traffic to just let that person go?
Well, Your Honor, if the officer sees a person pulling out of a bar at closing time, he may suspect that person's been drinking.
But that's different. That's not the facts here. This is where someone has told the officer that person is drunk. Do you think it would be reasonable? Do you think a reasonable police officer would allow that person to pull out into traffic in that situation?
Well, and that's not the standard either, Your Honor.
Well, the overriding standard of the Fourth Amendment is reasonable. So I'm just asking, do you think it would have been reasonable to allow this person to pull out into traffic after the officer had been told that that person was driving drunk?
I think it would certainly be reasonable to say, hey, can you stick around? Hey, what's your name? Those things take no time at all. And in those situations, we have a lot more information. We're able to
Counselor,
actually
let's assume for the sake of argument, the police officer said, thank you for the information. Can you wait right here? And went on and did exactly what he did with Ms. Tidwell. But the citizen informant or the person who gave the information did not stay around. Does that make this case different?
I think if the person didn't stick around, then yes, I think that cuts in my favor.
Why?
Because then, if a defendant flees from the scene, the state's entitled to a jury instruction that flight from the scene is consciousness of guilt.
But the informant is not a defendant.
Correct, but by analogy. And if he's asked to stick around and doesn't, then I think that takes away from the veracity that should be given to that person.
Why?
Because
Counsel, if the officer goes about his duty under Justice Stewart's scenario, and after having requested, not ordered, but requested the informant to stick around, and the informant leaves, that doesn't impact on what was said to the officer to give them the reasonable suspicion to act, nor what subsequently flowed from that. The observation of the glassy eyes, the exaggerated movements, the blank stare, that all comes afterwards.
I guess it does depend on the timing, Your Honor. If Trooper Islands would have said, hey, please stick around, and the person said, no, I'm leaving right away, I guess that's something that's known before the stop. But if he asked the person to stick around, while I would say that's a more reasonable thing to do than nothing, then I would agree with your point.
But Mr. Bradington, don't we want to encourage citizens to, particularly matters involving safety, don't we want to encourage citizens to notify law enforcement? I mean, don't we want to discourage people standing idly by and not reporting something suspicious, as you know, as said by your opposing counsel, their lives that could have been saved from this? So
yes, the phrase from appellant's brief was, if you see something, say something. But it's important to keep in mind that there's no evidence below or anywhere that this person actually saw or observed or witnessed anything. They were merely told by the Speedway clerk to tell Trooper Islands this information. So,
but that doesn't mean that the informant didn't see for his or herself that Ms. Tidwell was intoxicated.
Well, that's correct, Your Honor, but that would be presuming a fact not in the record, and of course it's appellant's burden at this point, and that evidence was not presented below.
Okay.
Mr. Brittingham,
Yes.
do you agree that she voluntarily handed her keys to the officer and he didn't take them out of the ignition, correct?
He did not take them out of the ignition, is my understanding. He said, give me your keys. So I guess voluntarily giving them to her I may slightly disagree, but he said, give me your keys, and she gave him her keys.
Thank you.
Thank you.
So what happens if this person, say this person, the officer had done nothing, he's ignored the tip, the person pulls out into traffic, kills someone, don't you think that there would be a lawsuit against the police saying that the police officer was reckless for ignoring the tip that someone was drunk, was about to pull onto the highway?
first of all, how would that tip come to light? The tipster is unknown. No one would ever know that the tip was even
Well,
made.
okay, that's not really the point, though. Maybe the officer told someone, maybe the clerk told someone, but
I guess I fail to see the relevance here in the determination as to why.
well, it seems pretty relevant if we would think that it was misconduct by the police not to do something here. So,
Well, I think it's important not to get lost here that we've got a state patrol officer acting on entirely private property. And under 550302 of the Ohio Revised Code, he doesn't have jurisdiction to even stop someone on private property. So I would think that would absolve him, and I don't practice in personal injury or any of those areas, but I would think that would absolve him of potential liability and that he didn't even have jurisdiction to stop the person.
So an officer, a state trooper cannot react to a crime being committed if it's on private property and not a highway. Is that what you're saying?
That's what 550302 says.
The crime is, well, does that, the sheriff was there, right? Didn't the sheriff
The
follow
sheriff
up on this?
The sheriff didn't arrive until about 5 minutes later, and she was detained after Trooper Islands had taken her keys. She was detained for that time.
so you think any arrest that occurs in a public parking lot owned by a business is illegal? Is that what you're saying?
In State v. Brown, this court looked at a situation where a township officer from Township A witnesses a traffic violation in Township B, and the court analyzed the statute that granted the township officer the police powers and said, even with probable cause and even with observing that traffic violation, there's no jurisdiction to stop that motorist, and the stop and everything after was suppressed. So in the same situation here, 550302 grants state patrol troopers their police powers, and it grants power on state roads, highways, and government or state-owned land, none of which we have here. So I think that would likely.
Did you raise that argument below?
I did. And the motion to suppress was granted in its entirety. So the state chose to focus on this issue, but I want to point out to the court that the appellant focuses the court's attention in the wrong direction here. OVI prevention is a laudatory goal, but the proper analysis or the proper framing is Ms. Tidwell's constitutional right to be free from unreasonable search and seizure versus appellant's interest in having Trooper Island stop someone without statutory jurisdiction to do so based on an anonymous tip. Now, Terry requires reasonable suspicion based on specific articulable facts before a stop will pass constitutional muster. And here, there's no specificity. There's no facts here. There's much less articulable facts. There's simply a secondhand opinion. In the first paragraph of its argument, appellant frames Terry as affording protections to the public. That's an incorrect and misleading interpretation of the Supreme Court's holding in that case. Terry protects individuals from stops and searches without reasonable suspicion. And that twisting of Terry is required to find in favor of the appellant here. To find for appellant, you need to say that OVI prevention is so important that reasonable suspicion is no longer required to stop a motorist. And appellant seems to realize that based on its framing of Terry in such a way. Of course, this would be a deviation from 53 years of jurisprudence. In Florida v. JL, the Supreme Court rejected a firearm exception to the reasonable suspicion requirement laid out in Terry. An appellant is essentially asking the court to carve out an OVI exception to that reasonable suspicion requirement. I'm out of time, so I'll close by saying just merely having a line of sight with a police officer does not transform an otherwise anonymous individual into a citizen.
Thank you. Mr. Cummings, you've used your time, or Mr. Kearney has used your time, so I'll give you a minute. You'll have to unmute yourself.
Thank you. A couple of quick points. The jurisdictional issue is not before this court. It wasn't addressed by the Court of Appeals. And specifically on page 84 of the trial court's decision, the trial court rejected that basis of the motion to suppress. So that's not properly addressed by this court this time. Justice Bruner, I know you mentioned about what rule of law we're interested in. The state's not interested in this court creating a new bright line rule of law. I think the whole beauty of the totality of circumstances test is just that. Every case has to have be weighed individually. I think what we're asking, though, is for this court to reject the appellee's request for a bright line rule in the courts below. They seem to think that if you don't have a name for a citizen informant at the scene, then this is going to be an anonymous tip situation. That's not accurate. That's not the case law. And that's the bright line rule that we think is so important that this court push back against and send that message to the courts of the state of Ohio, because this is going to happen again and again and again. And we cannot have a type of confusion where officers are hesitant to stop somebody from driving drunk just because they don't have the name of the citizen who's standing in front of them and they forgot to get it. Basically, the officers, they're here to protect and serve, and that's their business. That's why they put the uniform and the badge on every day. And in a situation like this, the officer did exactly what the public would hope and expect the officer to do. And I hope that this court sees fit to send a message that his actions were reasonable, they were constitutionally sound, admirable, and this is the way to conduct an investigation under circumstances like this, where you have no reason not to doubt the citizen informant. And real quickly, to your point, Justice Stewart, I think if the person makes an affirmative attempt to maintain their anonymity at the scene, I think that certainly would weigh in the totality of circumstances analysis, but we don't have that here. This citizen did his duty. Ostensibly, the officer assumed he was doing the duty that a concerned citizen would do. So in this case, it certainly cuts in favor of the officer taking action.
Thank you. Thank you, Mr. Cummings. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision.
Thank you.
Good morning. Our second case is 2020-303, Mark Johnson individually and as guardian of David Johnson and incompetent Glenda Johnson and Gary Johnson versus Anthony Abdullah, MD. For Dr. Abdullah is Mr. Welch.
Good morning. May it please the court, I'm John Welch and I represent Dr. Anthony Abdullah. I would like to reserve 3 minutes for rebuttal. Dr. Abdullah urges this court to reverse the judgment of the First District Court of Appeals, which opinion reversed a unanimous jury verdict in favor of Dr. Abdullah in a medical malpractice case. All 8 jurors finding Dr. Abdullah not negligent in his care and treatment of David Johnson. The First District reviewed de novo a entirely discretionary matter, weighed in on the credibility of the expert witness at issue, and substituted its own judgment for that of the trial court. By coming to its own conclusions on this witness's credibility, it really ignored and violated longstanding principles that the trial court or the trial judge has discretionary authority to determine competency of witnesses.
Counsel, let me ask you this. There's no dispute, is there not, that Dr. Walls was competent to testify when this action accrued?
Certainly that is our position, that he was challenged even at the time the cause of action accrued. But we think it is very clear that he was. He was a full-time practicing emergency medicine physician. He was chairman of the Department of Emergency Medicine at Brigham and Women's Hospital. in Boston, full professor at Harvard, teaching and editing textbooks and writing literature and researching and so forth.
And should that not be the standard, that if the expert is competent at the time the action accrued? You know, oftentimes medical malpractice case take years to get to trial, and sometimes plaintiffs 41A the case, things can happen. The expert, like in this case, can take on new responsibilities that may not fit with the rule, but
they do, and that's exactly what happened in this case. I think this court over the years, particularly the Selmer case in 2007, has said generally the rule is, it's in present tense, and that's the way the rule is phrased, but generally at the time of trial or at the time of testimony, the physician needs to be qualified or competent under the rule, or spend 50% of his professional time in the active clinical practice of medicine or its instruction. But I think this court and other Ohio courts have been relatively clear over the years that when a physician, as in this case, and as in the Selmer case, changes his role during the pendency of the case, the trial court still has discretion to determine that witness for that particular case is competent under the rule to testify.
Mr. Welch, is it, so you're saying at the time that the cause of action accrued, or at the time of Dr. Walls' testimony, at either time or both times, he satisfied all the requirements for Rule 601D?
Is our position, apologize, Justice.
Go ahead.
It is our position he qualified at both times. All right,
Okay,
so
my question, at one point, the Court of Appeals said, I think in footnote 2, that his teaching time doesn't count. I'm not sure what that means. And then when the trial court said, you know, do you do at least 50% of your time, the clinical work, Dr. Walls' response was, everything that happens related to patient care in our hospital is my direct responsibility.
yes.
Which is not a direct answer to the question. And if the question is being asked whether you provide 50% of your time is patient care, and then to say, you know, as the head person of the hospital, well, everything is mine, is not the same thing.
It's not the same thing as providing bedside patient care.
Correct.
But I think as the McCrory case and some of the other, well, particularly the McCrory case, is that there are some physicians whose duties and responsibilities are adjunctive or related to patient care. And I think that's how Dr. Walls was answering that particular question. There's no question that his role during the pendency of the case did change. And there was a 41A in the case. But to answer your question, Justice, I think that's how he was answering the question. The other issue at the time of trial is that Dr. Walls had not, you know, he was still teaching and still writing. So he is a researcher and was well published in emergency medicine, and particularly on the precise issues in this case, which was airway management and intubation in the emergency department. That was really the issue in the case. And Dr. Walls had spent most of his career on that particular subject. But even at the time of trial, when his role had changed, he was still editor-in-chief of the major emergency medicine.
He had no patient hands-on responsibilities, correct?
He had no direct patient bedside patient care responsibilities, except for
counsel. He didn't have a patient that he was the treating physician for. Is that a fair statement?
That's a fair statement.
And he taught 6 hours a year. Is that what I read?
At the time of trial, he would directly teach every couple of months. Yes.
But it was 6 hours a year.
Yeah, I thought it was 6 hours every 3 months, but you may be correct.
Okay, and so he had administrative responsibilities. And how long had he been COO?
He became COO in 2015. The case started in 2012. The care and treatment at issue was in 2011. And he became COO in 2015. And I think what he did explain during the voir dire examination, I mean, the trial court did a voir dire examination, asked its own questions, and I think satisfied, particularly with respect to the fact that he was still editing the textbooks and editor-in-chief up to date, which is what treating physicians often go to in terms of intubation and so forth, even at the time of the trial. So I think the trial court, given his history, his experience, what he was doing in 2011, and given the issues in this particular case, was satisfied that he was competent under the, certainly satisfied the purpose, and my position would be the spirit of the rule to justify in this case.
But not, counsel, but not the active clinical practice of medicine. You would agree he was not involved in the active clinical practice of medicine?
He was not
50%
involved
of
in
his
the
time.
active clinical practice of medicine as it relates to direct patient care.
Well, what, I guess, let's define the active clinical practice of medicine.
Yeah. And the active clinical practice of medicine has been defined differently over the years. And I go back to the McCrory case, in which a researcher who spent, a physician who spent 85% of his time in research, was by this court was deemed competent to testify on that particular case. And the reason is that given that researcher's duties and activities in doing clinical research, it was adjunctive or related to patient care, related to physicians who are providing the bedside care and treatment to a patient.
And
that was
counsel,
adjunctive.
in this case, isn't it a fact that the COO position that he ascended to couldn't have been filled by anyone? It was a requirement that it be filled by a medical doctor like Dr. Walls. Is that correct?
That is correct.
Because he had a direct relationship to the care that was being administered in that hospital.
Well, that's right. So that position has to be filled by a physician, because part of that physician's role is to monitor and supervise other physicians who are providing that direct patient care. So even though at the time, admittedly, he was a step removed, but I think, one of the reasons is that, and I think I liken it to the McCrory case, but active clinical practice of medicine has been defined as including those physicians or those other activities and duties that are adjunctive and affect maybe indirectly patient care. And I think that's what we have in this particular case, even in Dr. Wall's position as COO, because what he does is supervising, and everything he does is related to patient care, but also given his experience and is continuing to research and write about the issue in this case, much like the McCrory case, because that clinical research was working on, and he had a group of researchers working on a medication called Dilantin, but that was the issue in that case. And so it was within the discretionary authority of the trial court to allow that physician to testify.
Mr. Welch, so are you saying that it is within the discretion of the trial court to accept someone as an expert in a particular field, even if he or she does not directly satisfy the criteria of the evidence rule?
Yes, and I think that's what this court said in the Selmer case in 2007, that generally an expert witness must satisfy the 50% rule at the time of testimony, but the trial court has discretion to, in an appropriate case, to deem a physician competent to testify under the rule. A narrow interpretation or a black and white application of the rule has really been, over the years, rejected by this court, both in the McCrory case and I think the Selmer case. And I think that...
Are there other evidence rules that courts have the discretion not to follow? It seems kind of a novel argument that the court can or can choose not to follow the rules of evidence.
Well, I think...
What other evidence rules fall into that category?
Well, I think that in applying certain evidence rules, there is some discretionary, some discretionary authority. And I think particularly with respect to 601E, over the years, I think this court has rejected a narrow interpretation depending on the active clinical practice.
But I mean, no reasonable, if you asked an average reasonable speaker of the English language, none of them would say to you that this doctor was engaged in the active clinical practice of medicine, would they?
I think, Justice, I think it depends on how you define active clinical practice of medicine.
Well, I mean, what do those words mean to an average person, someone who's actively clinically practicing medicine? No, if you asked someone, ordinary speaker of the English language, they wouldn't say that he was engaged in the active clinical practice of medicine, would they?
I think at the time of trial as COO, again, active clinical practice could be, okay, patient care, bedside care.
I don't want a lawyer's definition. I want, how would the average person understand this?
The average person.
These are common English words.
Right. The average person would probably say bedside patient care.
Okay.
That's what and so that's what the average person would say. But I think legally, I think this court over the years has defined it more broadly. And I think that's the point. And I think what the trial court did here is there were motions in limine. He looked at the depositions, looked at Dr. Wall's testimony, and accepted his testimony while doing a voir dire examination, asking its own questions. What the Court of Appeals did, and when they looked at it and said, well, doesn't matter what the trial court says, we are not convinced. Dr. Walls strikes us as quintessentially administrative. We are not convinced. And so what I think that what the Court of Appeals did is they made their own judgment. And I think they now invite a de novo review of this sort of discretionary matter, because if an expert, a trial court could make a decision, and now almost every case we could go to the Court of Appeals. What do you think? How does this witness strike you?
Mr. Welch, I mean, a lot of evidentiary questions are mixed questions of fact and law. So I'm supposing the Court of Appeals saw this as greater a question of law than perhaps of fact. And if that's the case, how do you help us understand what facts the trial court had before it to base its discretion and move in the direction it did?
I think they had Dr. Wall's full deposition testimony. I think the trial court conducted its own voir dire examination where the trial court asked its own questions to the point that the trial court was satisfied that this witness for this case.
Counsel, I don't think that there's any argument that this physician was an expert in this field, in this subject matter, respected in his field, and produced learned treatises that other physicians could obviously use, treat their patients successfully by following his directives. And that's, I would say from my point of view, I'd probably want somebody like that, as my expert to explain what went wrong, etc. But that's not what the rule says. Now, we're stuck with the rule. And we're stuck with the clinical practice component, the 50%. And the reason we have that is because there must have been at a time a host of retired physicians that were out there, and I read the term hired guns in the analysis here. And that's what this rule was put in place to avoid. Are we in agreement on that?
We are. Certainly it is. Yep.
Yeah, and I don't think that there's anybody that would accuse this physician of being a hired gun. However, we've got the rule, and that's the stumbling block I see.
Understood. And I think, as this court said in Selmer, generally the rule is present tense, but the trial court has its discretion in a case like this, like in Selmer, that when a physician like Dr. Walls, who's certainly qualified on the issue, his role changes, that court has discretion. And that discretion will not be reversed absent a clear showing that it was abused. And I don't think it was abused in this case. I think what the Court of Appeals did is made its own judgment. And I think they invite de novo review.
So one last analogy to
Yes.
ask you. One thing that moved me somewhat when I was preparing to hear your argument was the amount of time that he spent doing rounds with other physicians. It turns out, though, that was pretty limited per week, but maybe like 6. What was that amount again?
Yeah, that was, I think he would do that, doing rounds with physicians where the other physicians were providing patient care. I think that was the 6 hours, and I thought it was per month, but
Yeah.
yeah, otherwise he was, still responsible for those departments and those physicians to deliver.
But
And-
so the analogy I was getting is I think about a machine operator in a factory and a shop foreman. And oftentimes the foreman will have a good bird's eye view, having worked his way up the ranks or her way up the ranks. But in this case, he wasn't really spending that much time in the emergency room as COO and with the other things he was doing, was he?
Specifically in the emergency room, no, it would have been part of it, but he would have been in other parts of the other departments in the hospital for sure.
Okay, thank
But
you.
not, his role as COO, yeah, was admittedly not confined or limited to the emergency medicine. It was included, but obviously he was coordinating care throughout the hospital.
Thank you.
Thank you, Mr. Welch.
Thank you. I'm out of time.
Mr. Bowman, you'll unmute yourself.
Yes, may it please the court. I'm Kevin Bowman. I represent Mark Johnson and the Johnson family in this litigation. I'd like to quickly address 2 issues raised by Justice Donnelly, where I'd like to issue a correction. Justice Donnelly asked Mr. Welch if there was no dispute as to whether Dr. Walls was practicing medicine more than 50% at the time that the action accrued. That is certainly in dispute. The Court of Appeals wrote that even if it were inclined to extend the Selmer exception, and turn the rule on its head and say it's at the time that the action accrued and not at the action time that the testimony is given, which is what Selmer actually says, that we are not convinced Dr. Walls satisfied evidence rule 601D at the time the action accrued. Dr. Walls' testimony on that was that he spent 50% of his time doing administrative duties, 50% of his time doing clinical practice, but also an additional 5% of his time was spent doing medical review expert testimony cases, which when you add it up, drops below 50%. That's why the Court of Appeals said that. That was not the reason that Judge Ruhlman in this case decided that Dr. Walsh was qualified to testify. He was not applying the Selmer rule. But as the Court of Appeals said, even if you did somehow stretch the rule in Selmer, essentially turn it on its head, where the court said, generally the rule applies in the present tense at the time that the doctor is testifying, and said instead that somehow it applies generally at the time that the action accrued. The evidence was very, very much in dispute. And the evidence, in fact, was not sufficient to show that he worked more than 50%.
So, Mr. Bowman, if you have reasonable minds on both sides disputing, to what degree they meet the criteria of this rule, how is the decision to allow him to testify an abuse of discretion as we define it, a decision that is so unreasonable, it reflects a perversity of will? How does it arise to that level of, in this case, to an abuse of discretion by the trial court? When there's reasonable minds on both sides saying he meets it.
If this were an issue of fact, if there were genuinely an issue of fact, if this was an issue of credibility, then the court would have absolute discretion. It would practically be unreviewable on appeal. But what is actually happening here is application of a rule of law. And when a court applies a rule of law incorrectly or fails to apply a rule of law, that is an abuse of discretion.
Let me ask you this. Hypothetically speaking, if we could agree that he was competent at the time it accrued, okay, and wouldn't a ruling in your favor be for plaintiff's counsel who, when they begin an action like this, invest money and hire up an expert that may be competent, but during the pendency of the case takes on different roles, just like Dr. Walls, and may not fit the criteria by the time the case goes to trial? Isn't that a bad precedent to uphold for both sides?
I think the Selmer case addresses that and addresses it adequately. In the Selmer case, where the plaintiff was responsible for asking for a number of vacations of the trial date, the court was given discretion to allow the expert. In this case, the actual case was filed in 2015. When it was filed, when we filed the refiled action, Dr. Walls had already been promoted to COO. So during the entire pendency of this case, from filing to trial, he was COO, and in his own words, was performing 90% of the time purely administrative and executive functions. So, I mean, I do think that there is some discretion under Selmer, but that rule is broken to the breaking point in this case where the plaintiffs did nothing. If we had gone to trial in the first action, he would have been promoted to COO. And the general rule is that at the time of testimony, when we refiled this action, Dr. Walls had never given deposition testimony before. He hadn't issued any report. It would have been perfectly easy when the action was refiled for the defendants to have chosen a different expert, one that was actually competent to testify. But when they actually named him as expert, he was not competent to testify.
Mr. Bowman, his specialty, he had a real focus on the issues that affected what allegedly injured your client. So we trade that off for the 50%, correct?
I'm not sure I understand the question, Your Honor, but I mean, I think that the rule is what it says, and the rule has to be applied even in cases where you find an expert who has a, like Dr. Walls, he's a fine physician. He could have testified regarding causation. He could have testified regarding any number of things, but the rule specifically says he can't testify regarding the standard of review. And I think part of that is that it's not fair for doctors who are out there practicing to be judged by a doctor who's not practicing. That's part of what the rule is. And,
but do you think his circumstances were special, though, because of his position as COO requiring that it be a doctor and his close work with other doctors who were practicing, so that he still kind of had his fingers in the pot, but from a little bit more of a bird's eye view?
Well, I think that's one of the other things I wanted to correct was I don't believe there's any testimony to that effect. It is certainly not true that his job requires a doctor, because as of today, as we sit here, Dr. Walls was promoted to COO of Mass General, and his job is now being performed by a master's in program management, MPM, not a doctor.
Is that in the record?
It is not, because it just happened. It happened in September. But as a practical matter, there's no evidence in the record that his job required him to be a doctor. He was a doctor who happened to be promoted. And the reality is that, throughout Ohio, there are hundreds, maybe thousands of hospital administrators who are not doctors. If hospital administration, if performing those kinds of functions qualifies as the clinical practice of medicine, then all those doctors are all those non-doctor administrators are practicing medicine without a license. The reality is there's no evidence that Dr. Walls was required to be a doctor to perform his function. If that were true, the person doing his job right now would not be an MPM instead of a doctor. Mr. Welch has said that this is an issue of credibility. And the reality is that no one in this litigation, certainly not appellee's counsel, certainly not the Court of Appeals, has ever suggested that Dr. Walls was not telling the truth. The issue is whether the truth, as reported by Dr. Walls, fits the requirements of the rule as written, 601E2. And was Dr. Walls telling the truth when he said 90% of his time was spent in matters that were purely administrative or executive? Of course he was. Was he telling the truth when he said he no longer sees patients? Of course he was. Was he telling the truth when he said he no longer teaches students or performs rounds with residents, that he only performs a round on a limited basis with the chief nurse? Absolutely he was. And the question is, does that fit the requirements of the rule? For Judge Ruhlman, it was enough that Dr. Walls got up and said, I'm a very important person, which he is. I have this exalted medical history as a practicing doctor in the past, which he does. He would have been a fine doctor to testify regarding causation, but he just didn't fit the rule.
Counsel, you were able, or trial counsel was able to cross-examine the doctor about all these issues and bring out what you perceive as weaknesses in his credibility.
Certainly.
Correct?
That was me.
Right.
I've adhered to the expert when he testified at trial, and I took his deposition. I did all those things, right? But I mean, the issue is, again, there's no factual issue. Nobody disagrees with anything Dr. Walls says. The question is legally whether the things that he said can be characterized as fitting under the rule. And when the Court of Appeals, expressed doubt regarding those things, it was expressing doubt regarding Mr. Welch's legal arguments. It was not expressing any doubt regarding Dr. Walls' truthfulness. I don't have any doubt that Dr. Walls is a very truthful person, but when the court asked him, do you spend 50% of your time, more than 50% of your time in active clinical practice? He didn't answer that question. As Justice Stewart said, he answered a completely different question. He said, well, everything that I do has a major impact on clinical practice. He testified at trial, when I have to make these decisions regarding funding, I have to make these decisions regarding staffing, I have to make these decisions regarding technology. I have no doubt that they're very, very important decisions, but they're not decisions that fit within what the English language, as you read the rule, what an ordinary person would say is clinical practice. They don't even fit what a lawyer would say is active clinical practice. There is no possibility of distorting those words, active clinical practice, to include what Dr. Walls did. Is that fair? I didn't write the rule. I mean, the rule was intended to do what the rule is intended to do. And part of that is that when we're talking about making decisions regarding standard of care, we only want to hear from doctors that are currently practicing, because that's fair on both sides, right? What's sauce for the goose is sauce for the gander. That's what the rules.
Counsel, let me ask it this way then. If a fourth year medical student, when the events occur and goes into this area of practice, 7 years later testifies, but was never practicing at the time of the occurrence. And with the human genome being mapped and all that, practice has changed. Under your analysis, that person could testify, correct?
Yes.
What kind of evidence is that?
That unless the standard had changed significantly from the time that the doctor was testifying, he was, at the time he's testifying, if he's a practicing doctor who knows the standard of care applicable to whatever the treatment is.
He would know the applicable treatment 6 years later, but he would not know the applicable treatment 6 years earlier.
Well, only if it had changed, and certainly that would be a subject for cross-examination.
Okay.
But it's not a question of competence, because that's the way the rule is written. I mean, if the court wanted to rewrite the rule to say something other than present tense, and it wanted to overrule Selmer, which says that generally the rule is written in the present tense and intended to act that way, you would have, I suppose, the opportunity to do that. But the rule says what it says, right? I mean,
Counsel, let's say you're correct and the judge made a mistake and allowed testimony that didn't exactly fit with the rule, given the debate between the two counsel here. trial court judges make mistakes all the time regarding evidentiary rules. They'll let hearsay in that it really isn't, shouldn't be allowed in. But we don't, every time that happens, we don't say that the judge abused their discretion. How is the decision to allow this testimony such an abuse of perversity of will that it amounted to an abuse of trial court discretion?
Because it was a complete failure to apply the rule. And it was non-harmless error. I mean, it was certainly error, right? Letting Dr. Walls testify was error under the rule because he didn't qualify. And then the question is, could you dismiss that as harmless error? And the answer is no. It probably had a very profound effect on the jury's decision.
So, Mr. Bowman, had the procedures changed from the time when he would have qualified to when he testified?
I don't believe there was any evidence of a change in applicable standard of care.
Thank you.
So, the rule requires that a person devotes at least half of his professional time to the active clinical practice in his field of licensure or in its instruction in an accredited school. And the testimony, which is not, there's not an issue of credibility. It was simply what Dr. Walls was saying. It did not fit that. When I asked him, just to be clear, whether his purely administrative and executive functions overlapped with clinical practice, he said no. I would argue that what I do influences and steers and directs and determines clinical practice. And that's just not the same thing. If that's what the rule required, that somebody be very important and that they what they do influences clinical practice, then I would say that rule, that imaginary rule applied. But it does not, in this case, Dr. Walls simply didn't meet the standards.
Thank you, Mr. Bowman. Mr. Welch?
Thank you, Your Honor.
You've used your time. You may take a minute.
All right, thank you very much. 3 quick points. As Mr. Bowman said that the Court of Appeals, they didn't disbelieve Dr. Walls. When it comes to Dr. Walls's testimony about his duties and activities at the time of care, he clearly said that only 25% of his time was purely, had nothing to do with patient care. So I don't think there's, from Dr. Walls's own testimony, I don't think there's any question that he qualified at the time that the care was provided. The trial judge applied the correct evidence rule and applied the correct law by doing the voir dire, asking questions about his experience and so forth under the case law, including McCrory and Selmer. One final point, as Justice asked whether the standard of care had changed from 2011 to 2017. It may not have changed in significant respects, but one of the things Dr. Walls was still doing at the time of trial was writing about the standard of care in terms of being editor of Up to Date, which is an online reference manual that clinicians use in real time. Had they gone to that Up to Date in 2017 to learn about intubation or indications of intubation, they would have seen Dr. Walls' name. That's all. Thank you.
Thank you. Thank you, gentlemen. We'll take the matter under advisement and you will be notified of our decision. Marshall, will you call a recess, please?
Thank you, Your Honor.
Thank you.
The court will now adjourn for a brief recess.
Good morning. Our last case this morning is 2020-415, the state of Ohio versus Harry A. Bond. For the appellant, Ms. Schumacher.
Chief Justice O'Connor, fellow justices, may it please the court. Jody Schumacher, on behalf of appellant, state of Ohio, representing Richland County. I ask to reserve 3 minutes for rebuttal, Your Honor. Thank you. Your Honors, the state is asking this court to correct the error of the 5th District in not applying plain error analysis to the partial closure of the courtroom during the course of trial, that partial closure having resulted from a near brawl breaking out outside that courtroom during a recess immediately following an identifying witness's testimony. Now, we're not asking the court to find anything inconsistent with current case law that this court has held, as well as the U.S. Supreme Court. We're simply asking to apply the current law and correct the error of that 5th District. Additionally, even under the structural error analysis, I believe the 5th District erred in finding error, and I can explain that. The state recognizes that the right to the open trial is certainly a fundamental right, but is a right that has to yield at times. And this court has recognized that that right has to yield, including to the administration of justice. This the court has recognized that trial courts have authority to control the process, to control their courtroom, and they have discretion in order to do so.
So, counsel, the trial court judge in this case limited the attendance to strictly family members. Is that correct?
Family members of both the defendant as well as the victim and the press, Your Honor. Yes.
Okay, so let's talk about the press. I didn't see in the record where the exception was that the press would be allowed to attend.
So, strictly reading the record, Your Honor, I understand the court's concern. However, in the state's merit brief to the court over objection of counsel that was permitted, there's footnotes referencing the newspaper articles that were written on behalf of this trial or during the course of this trial. They're also dated. Additionally, during the record or on the record, there is reference, Your Honor, to the court reporter. The local reporter's name is referenced and whether him writing an article would be permitted or not, Your Honor.
Does the record reflect that he or she was allowed to remain in the courtroom after the restriction?
Your Honor, you're correct. It does not specifically indicate that, but because there is a finding or there isn't an articulated finding that he be permitted, I believe that that it's not critical to this case in that the court has said it's okay to go ahead and look to the findings or the entire record as a whole.
So are you saying that the court or that the press was not specifically excluded? So you're saying that the press was allowed?
That is a very good point, Your Honor. Exactly.
Okay, so was the press there?
Yes, the press was present and remained present throughout the entire duration of the remaining witnesses, as well as jury instructions, and then even came in during pronouncement of verdict, Your Honor.
Did the
And
trial court
we know that because of the articles that were subsequently written contemporaneously with what happened in the court that day. Is that correct?
You're exactly right, Madam Justice, Chief Justice. Yes.
But did the trial court judge make a record of that fact that the press would be allowed to remain and the only other participants were family members from both sides? he make a record of that?
Your Honor, the court did not directly articulate that. You are correct in observing that.
Okay, thank you.
Ms. Schumacher, no party sought to close the hearing, correct?
That is, yes, Your Honor, that is a great observation.
And so did the trial court discuss any alternatives on the record?
Yes, I believe that the court did discuss alternatives on the record. I point the court specifically to the transcript on page 266. There, the court, in coming back into or taking testimony just prior, the trial court instructed those present, stating that everyone is to be on their best behavior, or else no one will be watching. I think that in and of itself demonstrates that the court had considered alternatives to that partial closure. In addition, I would point the court to Sewell, where again, this court found that even though the record lacked specific articulated findings, this court stated that because partial closure is more narrow than full closure, alternatives were in fact considered, Your Honor.
But did the trial court actually make specific findings to support whatever level of closure it believed was appropriate?
Specific findings, no, Your Honor. But as the Sewell court, as Drummond, and as Weaver versus Massachusetts has states, we need to look to that the entire record. And it would be unconvincing to quote Weaver, the U.S. Supreme Court. They stated it'd be unconvincing to deem a trial fundamentally unfair just because the court omitted to announce factual findings before making an otherwise valid decision to close a courtroom.
Okay, so I want to just follow up with that. Weaver is in the context of ineffective assistance of counsel, but Waller is in the context of structural error. Can we keep those two differences clear? Because I don't think we can combine those two very effectively.
I think we can keep, Your Honor, these differences. And remember in Waller, and this goes to the plain error analysis, Waller is different because there was an objection at trial, and over trial counsel's objection, the court still closed the courtroom. And Weaver is different because Weaver, although it was a post-conviction argument, there was no lodging or notice of error prior to that post-conviction appeal. So I believe that's a distinction without a difference, regardless if it's post-conviction, regardless if it's appeal, the difference is the same, or the result is the same. If we don't find, go ahead.
Are you saying though that if structural error is not, if structural errors are not objected to before the trial court, that somehow this morphs into a plain error analysis? And I mean, is that what you're saying?
Essentially, yes, Your Honor. And this is following the Weaver court's decision, as well as, and I think the 4th District did a great job explaining this. The 4th District of Ohio in Tabor did a great job of explaining this. So we have essentially two structures. If there is objection lodged at trial, we go immediately to structural error. And structural error still stands. If error is found, it has to result in an automatic reversal without any consideration to harm. However, if there is no objection at trial, and recognizing that the trial court is in the best position to cure any defect, to cure any error, if we first notice that at appeal, at that point, there has to be a demonstration under plain error that one, there was error, that the error was obvious, and that the result would have been different but for that.
But structural error goes to constitutionality. And if you think about the essence of democracy and public trials, I mean, when we look at countries where they have closed trials, that the public can't be there, that the media isn't allowed in, and maybe could only report based on what somebody was in the courtroom. I mean, aren't we? I mean, structural error can never be waived. How do I reconcile that?
Your Honor, we are not waiving structural error, and we're not saying that structural error was in fact waived. The public's interest for public trial was met here. Media was present, Your Honor. Additionally, the defendant's rights were held at bay here, in the sense that the defendant's immediate family consistent with In re Oliver, was present. And there's nobody else that has the defendant's interests more at heart than his own family members. They were present in this hearing. And in addition, we have victims immediately family ready or present, further acknowledging the public interest as well as the victim rights interest, Your Honor.
We don't have secret tribunals without good cause for that. And there needs to be something in the record that supports that and that shows that the trial judge limited that as much as possible, because that's like the essence of our democracy. How do we deal with this?
I don't disagree, Your Honor, that that the closure of a courtroom is very important and it needs to be greatly accepted and rare at best. However, there was a substantial interest here. Because this was a partial closing, there was a substantial interest, and that was the administration of justice. There was a second disruption, and that is noted in the record in the transcript at page 256. If you follow D'Arco Stillwell's testimony and cross-examination that morning, you can feel the tension building in that transcript. And it builds to the point where, trial counsel, defense counsel had requested the court to order the spectators within the courtroom to refrain from commenting. So we had that, and immediately following then 10 pages later, when we take the recess, as soon as D'Arco Stillwell steps off the stand, we then have the near brawl that resulted in breaking the candy machine, of damaging courtroom or courthouse property. So that substantial interest in one, ensuring that we proceed without interruption, ensuring that due process can be received by that defendant, that undue prejudice is not imparted by these unruly spectators, Your Honor. I believe the court was well-founded under the guise of that substantial interest.
Isn't one of the reasons that there's not more findings in the record because there was no objection? If someone had objected, the judge would have had to, presumably would have explained more why he or she was doing what they did, right?
I agree, Your Honor. In addition, I think it can't fall on this court to recognize the facts that potentially defense recognized. The reason there is no objection is because they went along with and felt that this was in fact in his client's best interest. You can see by the court's response in using the term, "We are closing the courtroom," and more than a 20-minute break, despite announcing a 10-minute break, despite that 20-minute break was announced. I believe that demonstrates that this was contemplated and trial counsel perhaps felt this was in fact in their best interest. I appreciate your court's time. I recognize I am out of time. And at this point, I ask the court to reverse. Thank you.
Mr. Koenig, you have to unmute yourself, sir.
I've lost time because of Zoom, Your Honors. Justices, Honorable Justices, Ms. Schumacher, if it please the court, my name is Charles Koenig. I represent the defendant appellee, Kyrie Bond. Your Honors, quite simply, I would say to this court that on the basis of the existing law, as law currently stands today, there is no reason for this court to overturn the 5th District's decision in this case. What clearly happened in this case was a closure. There's no ifs, ands, or buts about that. In no way.
Counsel, what about the fact that the 5th District didn't seem to follow the U.S. Supreme Court precedent? I mean, we have the U.S. Supreme Court saying in Johnson that rejecting the argument that harmless error does not, plain error does not apply to unraised structural error claims. So I mean, how do we deal with those cases where the Supreme Court seems to have said the exact opposite of what the 5th District said?
Your Honor, with all due respect, I don't believe that the Supreme Court has ever said that.
The Supreme Court said in Johnson, quote, "The seriousness of the error does not remove consideration of it from the ambit of the federal rules of criminal procedure." Then the court went on to reject the argument that structural errors were outside of plain error review.
Your Honor, that is correct. And they did say that in the dicta. What I'm saying is I don't believe the Supreme Court has ever said that a plain error analysis is to apply to a structural error violation.
Well, they actually seem to have said just that. You have Johnson, you have Marcus, you have Puckett, where the court consistently seems to say that plain error analysis does apply to these things.
Well, Your Honor, I would have to respectfully disagree with that because although I understand what the court said and I've read those things, I believe what the court is talking about there is that there are situations where a plain error analysis should be considered. But what I'm saying is that the Supreme Court has never stated that plain error analysis is to be applied to a structural error. Structural error is limited
to be fair, it's come pretty close. It says structural error. In Weaver, it said carries with it no talismanic significance. It means only that the government is not entitled to deprive the defendant of a new trial by showing the error was harmless beyond a reasonable doubt.
I think that is, in fact, the thing that Weaver said with respect to this case, Your Honor.
Right.
That what structural error.
Well, excuse me. But what Weaver said was that if the defendant raises the error, what structural error can mean is that there's no ability for the state to say that the error was harmless beyond a reasonable doubt. It doesn't indicate that when an error is raised, that there is no plain error analysis. In fact, it seems to say just the opposite. I mean, you have four Supreme Court cases that seem to say pretty clearly the exact opposite of what you're arguing.
Well, Your Honor, and looking at Weaver, the most recent one of all, what Weaver was concerned about, Your Honor, was the fact that the structural error violation was not raised in a direct appeal. And in fact, what it said specifically in that case, if I could quote that, is that the factors and circumstances that might justify a temporary closure are best considered in the regular appellate process and not in the context of a later proceeding, a collateral attack. What the Weaver court said, Your Honor, was bring this before the attention of the appellate court and a direct appeal. You can do that as we did in this case here, Your Honor. This case is a case where we brought the structural error violation up on direct appeal.
Well,
there's nothing then that changes the nature of that error being a structural error. There's nothing that transforms it into an error that suddenly means it's no longer structural.
Counselor, did you object at the trial court level?
No, Your Honor, there was no objection at the trial court level. And Your Honor, I would say that while that may be an error on the part of the defense counsel, it doesn't change the nature of the violation. The violation is still a deprivation of a public trial right that was committed by the trial court. It's the trial court judge that is responsible for safeguarding the protections, the constitutional protections of the defendant. And in this case, it was a trial court that violated those protections.
But not all from the courtroom rise to the level of structural error, correct?
Correct, Your Honor. And in fact, that's a very, very good point that there's only about a half a dozen instances where there's structural error. And if what we were to say is those items, those instances of structural error require defense counsel to object at trial before they're treated as structural error, Your Honor, we lose structural error then for things such as not giving the defendant the right to have his own attorney present, not giving the defendant the right to participate as counsel, forcing the defendant to be tried before a biased court. If it's not objected to, the discrimination of a juror poll, if we say, well, it depends on whether your attorney was smart enough to object at trial, and if he's not smart enough to object at trial.
Counsel, I would agree with you if this was a complete closure, which I think would be a very different situation. And I doubt whether the defense attorney would have agreed to this. But apparently, at least based on what I understand of the record and based on the prosecutor's position here, this was an agreed upon procedure for a partial closure that allowed for the essential members of the public, that is his family, to be there. And more importantly, the press was there, and the press did cover it, write about it. and disseminate what was going on in the courtroom.
Your Honor, there's a lot in that I need to respond to. The first
Go
thing
ahead.
is that defense counsel did not agree to this, Your Honor. The defense counsel was foolish enough to go along with it and not object to it, but he did not agree to it. He did not ask the court for closure. The second thing is the record is devoid of any evidence that the press was allowed to attend. In fact, I would say the exact opposite. The court was clear that only immediate family members would attend. The fact that there's evidence outside the record that the court would be willing to consider as evidence that the press was there, I'm unfamiliar with that standard of review, Your Honor, but at the same time, I don't believe that because there was articles written that evidence is the fact that the press was present. Your Honor, yesterday I read an article about the new rover mission on Mars. I'm fairly certain that the author of that article was not on Mars, but he wrote about it. And you can write about things without being there. Police blotters are in the paper all the time without the writer being present at the scene of whatever that criminal activity was that's in the paper. And Your Honor, many times the press receives their information as a result of somebody from the court, usually the prosecutor's office, call in and let them know what happened at trial. So there's no evidence in the record that the press was present. However, Your Honor, even if the press was present, the court needs to remember that in State versus Drummond, the court did find the press was present there. And nevertheless, the court found that it was a closure, and it was a partial closure. And as a result of which, the court went through the Waller analysis to determine whether the closure was constitutionally permitted. The Waller analysis.
Counsel, if we were to adopt your position that says that any structural error is automatic reversal, what incentive would counsel ever have to object? And wouldn't the prudent counsel's best policy be to say, okay, let's wait to see how this trial turns out? I won't object. It'd be bad for my client to object. And then if I lose, I get an automatic do-over.
Yeah,
that seems contrary to everything that we learn about the purpose of the rules of appellate procedure.
Your Honor, first of all, it's not my position that structural error requires automatic reversal. It's the United States Supreme Court's position, and
well, with all due respect, counsel, that's not their position. They've never said that. They've said the opposite. You're arguing for a different position, but go ahead.
The United States Supreme Court has not said that structural error requires automatic reversal.
They have not. They have not said structural error. What they have said is that structural error, that there are categories of structural error that may preclude the state from arguing that error was harmless.
I'm sorry, Your Honor. I stand corrected. You are absolutely right that what it says is the government cannot deny the defendant a new trial by proving a harmless error. I agree with that. To me, that is the same thing as saying, ergo, you are entitled to automatic reversal. But
it's not the same thing. It's a different prong of the test, right? I mean, harmless error applies when there is an objection.
The second
plain error applies when there's no objection.
The second part of my response to your question, Your Honor, is that yes, defense counsel all the time uses strategies for the purpose of not only trying to win a trial, but thinking about what to do later on in an appeal. I don't believe, however, that when you look at constitutional errors, only the few that have been elevated to the level of structural errors, when you look at those constitutional errors and realize that there's only a few of them, and those few errors say that this is the result, this is what should happen then when this error is committed. I don't believe that counsel's performance at trial should in any way affect that.
Let me just get you to answer the question.
Sure.
So the smart thing, the strategic thing for counsel to do in a situation like this is not object.
No, Your Honor, it is not the smart thing to do. What it did was it by virtue of closing the trial to the public, Your Honor, and not following the constitutional requirements of closing.
But why would counsel ever want to object in this situation? It's a win for counsel if they don't object, if we adopt your rule, because either counsel, they get two bites of the apple, right? They have a trial and they can see if their client's found not guilty. If not, they get an automatic do-over. So why would you ever object?
Because, Your Honor, the purpose of trial counsel is to win the trial. It's not to continue to have more trials and more trials and more trials. But by virtue of a closure of the trial to the public, it tears the very fabric of the trial framework apart, Your Honor, and it destroys the integrity. It destroys the ability to be able to make sure that there are people in the audience that can watch the
Correct, Mr. Koenig, but as you admitted earlier, all closures are not violative of the defendant's constitutional rights.
No, Your Honor, I did not say that. In fact, I think all closures are violative unless there is compliance with Waller or Drummond, that where the overriding purpose or the substantial reason for the closure, in fact, overcomes the right to a public trial. Closing the public trial is a structural error. When you close the trial to the public, you deny the defendant.
Okay, but this was not a complete closure, correct?
Your Honor, I don't believe that there's a difference between a complete closure and a partial closure from a standpoint of how it affects the defendant. The only difference is whether everybody's excluded versus a couple of people excluded. Your Honor, in Drummond, when the court determined that that was a partial closure, the press was there, the family was there, and an extensive number of people in the family were there. In this case, you only had a couple of people there, no evidence that the press was there.
Counsel, Drummond's flaw was that there was not a substantial reason for the closure.
Correct, Your Honor, and in fact, that is the reason.
All right, so it really doesn't rely on the press being there, the family, etc.
Exactly.
It was the fact that there was no substantial reason found by the appellate court. So in this case, you've had the tension mounting. You have, obviously the two adverse groups. You have violence in the hallway. And so the judge considers a partial closure as the least restrictive, response. And the attorney for the defendant does not object. Now, you say did not agree. I think the opposing counsel would characterize it as acquiescing to the closure for the safety of client and client's family. So the substantial, we're focusing here, or I'd like you to focus on the substantial reason rather than an overriding interest. The overriding interest is the closure, total closure. Substantial is for partial closure. We have a partial closure. Do we not have a substantial reason?
You are correct, and Your Honor, I believe that the court is relying an awful lot about on things that the state put in their brief that's not part of the record. There was no reasons articulated in the record by the judge as to why he did the closure. There was an altercation in the hallway, is all we know. There was tension in a murder trial. I don't believe that that's anything strange about a murder trial. There's no indication there were fisticuffs. There's no indication anybody was hurt. In fact, we don't even know who was involved. For all we know, it was the witness and the victim's family that was involved, and the defendant had nothing to do with it. We don't know that any of the witnesses were there when it happened, that anybody was threatened. We don't know that the jurors knew about it. We know nothing about the altercation based upon what's in the record. There is no substantial reason in the record. There's substantial reasons set forth in the state's brief, but you can't find that in the record. And the 5th District, which did a painstaking analysis of everything that was in the record, found that there was no substantial reason stated by the court in the record. There just isn't a substantial reason for the closure. The judge just decided he wanted to close the courtroom because a gumball machine got broke in the hallway. And you can't tell anything more than that. Not even who was in.
Counsel, you've frozen on screen.
The things that would safeguard the defendant's constitutional right to a public trial. None of that was there. Okay, so there's no substantial reason shown, and there's nothing that the court did to figure out, is there something less we can do than exclude everybody? Because, Your Honor, in my brief, I raised in my brief to the appellate court, I raised 6 assignments of error. Some of them included the fact that witnesses changed their testimony, that there was inconsistent testimony, that there was prosecutorial misconduct. All of that stuff is safeguarded when the public is there to watch, listen, and say, I know that person's lying. And there's nobody in the courtroom who could say that. All that was left in the courtroom on the defendant's side was his mother and his sister. And they weren't there. They didn't know anything. They don't know the witnesses. Your Honor, there was no substantial reason articulated. There was no alternative methods considered. There was no reasons put on the record. No matter what, partial or total closure, Waller and Drummond were both ignored by the court. The court simply closed the courtroom because a gumball machine got broke in the hallway. And Your Honor, again, with all due respect to all of you that have questioned whether the Supreme Court has said structural error doesn't require a different treatment, if you will, when that occurs. It is the essence of the very fundamental characteristic of structural error is that you cannot tell whether the outcome of the trial was adversely affected. You can't figure out what was the harm from that occurring. And to say that, well, we're going to place now the burden on the defendant to prove prejudice because counsel didn't object, is taking away constitutional rights for, in my mind, no good reason, no compelling reason.
Thank you. Thank you, Mr. Koenig.
Thank you for your time.
Your Honors, to reiterate, the distinction, I'm sorry, go ahead.
Just one question that I've been wanting to ask. So we're in the direct appeal process, and Weaver has said, which was decided in an ineffective assistance of counsel setting that was not related to a direct appeal, but more post-conviction. So we still have the chance to let the trial court correct the situation, because if we affirm the 5th district, the trial court has to do it over again. And so we don't need to apply that thinking of plain error and proving those elements of plain error, because we're still in a direct appeal process. Am I right here?
Respectfully, Your Honor, I disagree. But if the courts, Your Honor, if you want to stay under the structural error analysis, the state would submit that there is no, we still can't demonstrate error because, in fact, the trial court had a substantial interest in closing the courtroom. It was, in fact, narrowly tailored. Alternatives were considered. And although the findings were not expressly placed on the record, the entire record demonstrates that it was the appropriate decision.
Counsel, what in the record supports the substantial reason for the partial closure? Your opposing counsel is adamant that there is no nexus between the violence in the hallway to the attendees at trial, that there's no testimony, there's no evidence that they were even, I guess, linked. So what did the judge find, state on the record, articulate whatever to support the substantial reason?
So articulating this is a substantial reason, he does indicate that there was an altercation in the lobby. He does indicate that I believe his words were a M&M machine was broken. Words alone do not result in a machine or property being broken. So I think it's context. To answer your question, Your Honor, it's context.
Okay, counsel, was there evidence that this was done by the people who were associated with this trial?
I believe so, Your Honor. When reading reading that entire transcript, the court does state that it was not family that was involved. Additionally, then what other interest of anybody? This immediately followed an identifying witness's testimony. After tension was rising, after in that courtroom, there was directives to the gallery or requests to that gallery to refrain from commenting. You feel that tension. I agree, Your Honor, there aren't specific findings, but it's in the record, the entire record, that it can be imparted that the administration of justice was at risk here, and it was necessary to partially close this courtroom.
Thank you. Thank you.
Thank you, Your Honors.
We'll take the matter under advisement and you'll be notified of our decision.
Thank you.
Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.